Good day, everyone. I'm Richard Fink, a lawyer who specializes in workers' compensation, and I'd like to introduce two of our co-panelists today. One is Pamela Hughes-Ford, who's a senior legal assistant in my law office, and the other is Paul Taylor. Paul?
Hey Richard, hi everyone. Notice how he saves the best for last. Actually, Pamela would be the best, so she should have been last. At any rate, my name is Paul Taylor. I'm a licensed paralegal with specialization in workers' compensation, human rights law. If you want to reach out to either Richard or myself and be part of our podcast, like Pamela and myself, you can contact us through the links below. This week's topic is administrative issues injured workers are facing when dealing with the WSIB. In my personal experience, I've been dealing with the WSIB for over 27 years as an injured worker. And oh God, it's been over 5 years now as a paralegal representing injured workers. And I would lump it up, Richard, by saying one phrase is that the WSIB is not giving injured workers enough respect as a person. And there's many examples in return to work. They're not listening to them when they say, I can't do that work, either by pain or by other disabilities, or there seems to be a presumption that the person is faking without any proof. That I would characterize as like a witch hunt or witch trial. And a very prominent case that I've spoke about many times was David Curtis, where there was no medical evidence when he went to the Court of Appeal. There was no medical evidence of these three injured workers being prosecuted for a material change or faking. There was no medical. I said that again. Yeah, sorry. There was no proof that they were faking medically. In David's case, the judge at trial literally said he's going to ignore the medical evidence. This scares me being a legal person because if the system doesn't work anymore and they're using personal opinions and feelings to make decisions, whether it's a case manager, a nurse case manager, an appeals officer, tribunal case vice chair, or a judge, our legal system is failing. And it gets back to that survey that I referenced about the law societies. Another issue or topic, and Pamela is going to speak with us too about it, is when the board gets frustrated in dealing with an injured worker. I know in dealing with many, and I'm sure Richard, you know too, is when you're an injured worker, you're facing not only your injury recovery, the pain, the lack of mobility, the function, the literally the fights with your friends and family, not to mention the fact that now you're struggling to pay your bills like rent, facing eviction. Doug Ford's just changing a law to make it easier. This becomes difficult in how you communicate your concerns to legal people and to the board. And it seems to me, in some cases I've heard about, the board is declaring them communication restrictive. And I just want to point something out that I find very ironic is that I will have injured workers that are suffering from severe mental conditions, disabilities, that when they literally see an envelope from the WSIB, they go into a panic attack. They can't function. The board literally is causing them harm when they're communicating with them. And there was a case at the Human Rights Tribunal, David Lawson v. WSIB, where the HRTO ordered them not to communicate with them anymore. And that was, he was represented by a very well-known lawyer, John McKinnon, who's been on here. And I've found myself where I've represented injured workers and I've had to repeatedly tell them, stop communicating with my client and said, this is a human rights accommodation. And they still do. It becomes a huge problem in this thing. And I think it all goes into that. What do you think, Pamela?
Well, we face a lot of challenges that you just referenced. So we have clients that call the WSIB and they get extremely upset because for good reason. They're waiting too long for decisions. They're not getting paid. We just had a situation this week where a client had moved. The WSIB sent a check to the wrong location. He said, "Don't worry about it. I'll call the WSIB myself," and then says, "I still haven't gotten the check." I call the WSIB and find out there's a check that's been placed on hold for an unknown reason. So he's obviously upset. He thought he was going to get money. He wanted to call the WSIB to get upset. And I said, listen, this is what we're here for. I'm going to call. So a lot of the times I tell our clients, If you have a problem, you call me, I call the WSIB because people get upset. People unfortunately lose their temper. Getting excuses or, sorry, reasons as to why things are backlogged. And I know I told you I was going to get this decision or this payment out to you, but something else has occurred, and now it's going to take 2 or 3 weeks later. I mean, I think anybody in their rightful mind would get upset. These people have bills to pay. It's coming into Christmas time. So people are just going to get upset about it. And on the WSIB's perspective, I get that they're backlogged. I get that there was a work disruption, and I understand this. However, I think that case managers should try more to put themselves in an injured worker's position. They know that they're getting paid every week or every 2 weeks. What if you were that injured worker and you're being told that there's a situation where you don't know when you're going to get paid or when a decision is going to be rendered? Like, I don't think that many people in the population actually do that. They don't look at the other person's perspective. So in our situation, we have two files right now that are in the security department because our clients acted inappropriately towards WSIB staff prior to them retaining us. So what happens is if you are threatening, abusive towards a WSIB staff member, you get a warning letter. You then get your file moved to the security department. And once it's in the security department, it does not come out, which means anybody that contacts the WSIB on that file, including the representative, cannot speak with anybody. The letters have to be sent directly to the security department, and the security department will write back to you. You do not get the file access electronically like we do with every other file. It comes by paper, and everything is on a separate system. Um, Also, nobody at the WSIB that's outside of the security department can actually see the claim file. So if you try to put in the claim number, a big screen comes up that says no access, and it has to go through to the security department.
I can see something like that, and I agree with taking precautions. Like I'm reminding of the boards, like they're human beings and they have rights to safety and everything, and that is first and foremost. There is no question about that. There was an example of safety concerns, and I'm sure much older people like my friend I know who can recall back to horror stories like that, and I can only remember Sudbury, I think it was. There was an incident there at Thunder Bay. I can't remember up north. But I do recently remember a story of where an injured worker went into an Edmonton WCB office and held them hostage. The sad part was he never got anything, and he became everything you just described. That's how, in fact, it was so high level security after the incident, after his jail time and everything, that he had to do everything through the police service. It was very difficult. Then, after that incident, what really surprised me was how the media portrayed this other injured worker who literally tried to set himself on fire and go into the WCB office. The media didn't say the simple question of why was he doing this? Utter, complete desperation. The system is not working, and he was that desperate. When people get to that point, the problem is the security system throws up a wall to protect, rightfully so. But then the other problem lies in they're not asking, why are these people getting this desperate? It's sadly you get people like Doug Ford saying, get a job, you're just being lazy, you're faking, instead of asking the deep questions as to, is the system working for these people? Is it
Did Doug
providing for
Ford
them?
say that during question period?
What's that?
When when did Doug Ford talk about get a job? Was that during the question period?
Yeah, the Hamilton Acorn, it was a guy from Hamilton Acorn, which is a tenant advocacy group. He was raising concern about Doug Ford's changes in the law, which basically remove rent caps for all
No.
tenants.
It
So if
wasn't
you
it
can,
wasn't a workers' comp thing.
no,
Yeah.
no. But it's his view, it's the view of a systemic view that we're seeing across the system, across society where they're viewing anybody that is struggling must be faking, must be pretending, doesn't want to work. And I'm reminding of a survey that was done in 2007 connecting homelessness to injured workers, where the study in Toronto found, I think it was a street health study, I think they said it was like 57 or 58% of the homeless said they were injured workers, and that was in 2007. There's been no recent research or more in-depth research, which is something I'd love to see. Because who are these homeless people? I'm not just saying, well, they're lazy, they're faking, just like injured workers. You need to ask the right questions. Why are you here? What's going on? And it seems to me like Pamela said, it's not the case managers or the appeals officers. It's the system. It's a wide problem where they're being told, just come on, quick, 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 quick. Get through that injured worker, get to the next, move, 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 like an assembly line at Ford or GM, where it's the faster, better. But one thing that you miss, Pamela, which is very deep, cuts deep to injured workers, is they're saying, well, we don't have time to spend on you and deal with this case
Yeah.
because we don't have enough workers. Okay, but you seem to have enough money to give back to employers. They've given, in my math, which isn't great, I believe $10 billion to employers. And that's what they've publicly announced. We don't know how much. Yesterday, the Auditor General said that Doug Ford's been advertising $120 million, advertise using monies,
Our
taxpayer
money.
monies. Yeah.
Yeah.
And the WSIB, in my opinion, wasn't included in that. So these are concerns that heighten people that are struggling. And another really infuriating thing is injured workers, with no disrespect to people that are struggling low income. Injured workers are lumped into the same category that you're lazy, you're faking, you're pretending you're a lazy bum when that isn't the case. They're workers. They were working but for their work accident. Now they can't work. And they're saying, well, you must be faking. And that's probably the biggest hurdle. I've been looking at wanting to do a study on the decisions at the tribunal and the board to see how many times the word faking, malingerer, functional overlay, or somatic, whatever, all these terms the board and tribunal uses to say, we think you're faking, to see how many times it comes up. I know in doing a few, it was actually shocking that there is a presumption of, like in criminal, you'd say presumption of innocence. But in this case, we'd say presumption of guilt or presumption of faking. And it's like in many cases, when I talk to injured workers now, and when I present cases in court, I say, our only crime was getting injured. Crime. That's what it feels like. It feels like now when you're an injured worker, you're a criminal. And I go back to that case that went to the Court of Appeal with the three injured workers, when that's all their crime was, is they got injured. The employer didn't like them. Not all, by the way, not all employers are horrible. There are a huge number of amazing employers, and I'm not promoting any or anything like that, but I know one client, one person that called me, and they said, Paul, this employer I'm with is horrible. They won't do anything. They won't help me or anything. But then this other employer I'm working with, I work part time with them, and I told them, she says, I told them that I was injured and that. And she says, you know what? Forget that other employer. Come in. We're going to sit down. We're going to help you. We're going to find a job that works for you. And I was like, that's amazing. But I knew the employer and I know what they're like. And that's what I'm saying. It's the ones that aren't. And those are the ones that are causing the most problems.
Well, it reminds me of the new workers' comp law passed in 1990 made specific reference to chronic pain that it would not be recognized. And it was the court case in Nova Scotia that said it was discriminatory to discriminate against injured workers on account of psychological problems, because chronic pain is generally looked at as a physical problem that then takes on a psychological slant. So there's obviously this long-standing view on the uh, sort of employer anti-worker stance that workers are exaggerating and being paid. Uh, really even goes back into the 1970s when injured workers are storming the legislature and the Ministry of Labor on the issue that they'd have a back injury, and then the WSIB would say, your problems are psychological and pre-existing degeneration, and back injury claims weren't paid. So this theory that injured workers should not be paid for psychological disruption has a history going back probably 50 or 60 years.
It's funny, Richard, in that case you're citing, and I've mentioned it before, and I've quoted the words from, and I'm going to do it now again, is quickly quote from the Supreme. And what's so funny, ironic, is that it's the first paragraph in the decision, and it's Nova Scotia v. Martin, and it says basically, pain continuing and non-painful stimuli being perceived as painful. These changes, it is believed, may be precipitated by peripheral events such as an accident, but may persist well beyond the normal recovery time for the precipitating event. How often have you heard, Richard, of the board saying, well, you should be recovered now, so we're done with you? Despite this reality, since chronic pain sufferers are impaired by a condition that cannot be supported by objective findings, how often, Richard, have you heard of the board saying, we demand objective medical findings? They have been subjected to persistent suspicion of malingering, faking, on the part of employers, workers' compensation officials, and even physicians, doctors. That right there, that says it all. And that was in 2003, that decision, where, as you said, Richard, they passed a law and said, we're only going to pay us so much for chronic pain. Today, the board's doing the exact same thing in Ontario. They pay you, what is it? If you get chronic pain entitlement, they change from an organic NEL to a chronic pain NEL or a psychological NEL, and that's it. And I was shocked to find they still expect workers who are suffering from chronic pain to go back to work. And I'm like, tomorrow I may be bedridden. Today I'm fine. Then maybe next week I'm in bed all week. This is what you hear from chronic pain sufferers, that it's not literally it is not a manageable condition. And this is something that the board doesn't seem to really be concerned about. It goes back to that phase back in 2010 when David Marshall, the president of the board, went to the legislature and said, I'm going to get tough to deal with this so-called fake unfunded liability thing. I say fake because it was the Ontario Auditor General who said, we want you to create a fund in case the board is gone tomorrow. So that way taxpayers don't have to fund it. Fine. But what they did, instead of raising premiums with employers, they cut their expenses in half. They did a 1990s corporate America system, American insurance system, deny, delay, defend. And they denied claims, delayed the claims, and this caused the board to pay that fund off in record time, reduce premiums by 50%, and now they have a surplus of 40, 50 billion that they've been slowly returning back to employers. It's beyond frustrating for injured workers. And what I do think, to be fair, with both sides, employers and injured workers and the government, taxpayers is the most important thing right now, is that because what people miss is if I'm an injured worker, I was injured at my employer's workplace, they should be taking care of me, meaning the WSIB, who's gotten the premiums from the employer. The employer shouldn't have to worry about me. I shouldn't have to worry about me, my family, nor taxpayers. But instead, the whole system seemingly isn't working. The majority of workers are struggling. This means workers have to go on to taxpayer-funded welfare, federal programs, and who's paying the price? Taxpayers. This system isn't working. For that, I think there should be an independent public inquiry. If you want to have some judges on it, cool, but I think there should be injured workers and employers on it, to be fair. That's all I ask as a rep and as an injured worker, that the person I appear before the panel or judge is fair and honest. I think that's the only thing people in a free and democratic society should ask of a
So,
legal
Paul,
system.
can you spend a couple minutes telling us what your lawsuit is about and where it stands at the moment?
Oh, you're talking about the charter class action. So as an injured worker learning the law and being silly and thinking that the system is fair for everyone, seemingly it isn't. And this I hear often. I filed a charter class claim because in our charter, unique from many other countries, when your right is violated, usually we hear, oh, so and so was like Richard was arrested for doing whatever, but the charges were dismissed by the judge because the police violated his rights when they collected the evidence. That's 24B, I think, or 24.2. 24.1 is for any other right that's been violated, right? And you can ask the court for any remedy, meaning even money or whatever, changing law. I usually hear change in law. So I asked injured workers across Canada, and I was shocked to learn that Ontario is not the only one that has these systemic problems where workers are facing discrimination based on age, where benefits end at 65, where they're deeming injured workers saying, well, we think you can work, and then they cut the benefits off. They're forcing them back to work. They're refusing them to declare them
What were
unemployed.
you asking the court to do?
I was asking the court in the original claim to award, I think it was 35 billion to a fund, and then that would pay out to the injured workers. Because in the board doing these processes, it was my position that they violated the charter rights of the individuals.
So you
Section
wanted
7.
them to create a fund to recompense workers who had been.
Yeah. It would go to, and I hate to say it, but it would go to a law firm who would manage everything. You know what I mean? I didn't want anything to do with it. I think the biggest thing was just to try and raise awareness that these problems are so bad that they're violating charter rights. They're not just ignoring the law and the human rights. It's
Which part of the charter were you arguing?
Section 7, which is security of person. For example, in that, the Supreme Court has long recognized a person has a right of autonomy, control over their body. I can decide what medical procedures I can have or not, and that's under security of person, Section 7. The board cannot force you to do medical treatment in Ontario. Then the other one is 12 is when you say to me, you have to return to work and you give me no choice and returning to work causes pain and suffering, that under Section 12, many people know it as cruel and unusual punishment, but it's cruel and unusual punishment and or treatment. And the Supreme Court has recognized the way people are treated in situations. If it is cruel and unusual, it is a violation of Section 12.
What happened to your case? Where does it stand now?
So just one second. So the other one that I did was Section 15, which everybody knows is right to equality, which would be physical disabilities, mental disabilities, and age. Then yeah, so the case dragged on for many years because the problem was, as injured workers, we were self-represented. We reached out to many big law firms, and the common response was workers' comp, we're not touching it. Because the feeling seems to be that injured workers, like a better example is looking at the Supreme Court decisions for the last 10 years in dealing with judicial review of administrative decisions. The majority are immigration law, refugees, things like that. I am not saying anything about them. Keep it the way it is, it's fine. I'm doing a comparison. If you look, there is zero or very few for injured workers. The answer is simple, there's no representation. And I believe the reason why is every time a workers' comp case hits a judge's desk, they immediately assume what the lawyers for them say is, you're trying to circumvent our legal system by suing us. And that's not the case. In fact, Richard, there was a case at the Supreme Court that clarified this and said that process was wrong. If I believe that the board violated my rights or committed a civil tort, then all I have to do is show that. Then I can sue for my damages and my benefits together. And the case was Telezone v. Canada, where the Supreme
Well,
Court said,
you're in a class action for all the injured workers who've been mistreated to obtain funds from the board to try and rectify their mistreatment. And where does the case stand now?
right now the judge of the Superior Court in Ontario dismissed it because the first motion was that we had to make a motion that we be appointed a lawyer. And the argument was that the law says the worker advisors to represent injured workers. The judge disagreed, dismissed our motion. Then the board and tribunal brought a motion to dismiss the claim, and of course they won that. Now what we have to do is bring a motion to the Court of Appeal to extend time to file the appeal if the board or tribunal doesn't consent to the motion.
Well, that explains that. So
Does it? No.
perhaps one further item, which is I get a lot of emails from Dave McDonald. What's his big issue?
Dave's issue was what me and Pamela were talking about, unfortunately, and I don't agree with it, is that he's frustrated with the system, and I get it, I am too. And he's asking, and he'll catch them in something, and he believes he has them on something, and it's one. I believe he's correct in his reasoning, and he's asking for an answer. And instead of them going, "Yes, you're right," or "We made a mistake," they're like, "No, we can't deal with you anymore." Um, it's very frustrating because the one thing, Pamela, that I didn't mention was the board, in my opinion, can't do that. They can't say, "We don't want to communicate with you." Because if you're trying to appeal a decision, you have what's called as procedural fairness rights, be able to know and be able to present your case fully and fairly before an impartial decision maker, and the right to be represented. That's basically the procedural fairness rights under Baker from the Supreme Court. The problem is to enforce your rights, and this is something you'll see across all board tenant, injured workers, human rights, all of them. You have to have the money to get a big, powerful lawyer to win a case. Like there was the injured worker in Alberta, and I mentioned it before, and I should look for the case. It was really cool. What happened was, Richard, what happens if you get a decision from the tribunal that say I'm your client, and you say, "Hey, Paul, we won. You got all your benefits. Yay." The decision goes to the board, and you call them up and say, "Okay, give him his money." And they go, "No." "What?" "No, we don't feel like it. We're not going to. We disagree. We're not going to." No. They don't follow the appeal. They don't go judicial, whatever. They just say, "No, we're not going to do it." So what do? So this injured worker hired a lawyer and filed a judicial review writ of mandamus. And the one thing I loved, and this is what's sad about our system, is that when you get excited about one decision, because the system is so slanted, that's a problem. Where when I heard the judge say this, I felt justice, I felt fairness. When the judge said, "You may not want to follow the appeals commission's decision, but you will follow mine or I will hold you in contempt." I went, "Yes." And that's bad because that should be, you should expect that fairness. You shouldn't have to go to a judge for something like this. And I think that's the bigger problem that we're having.
Let me just conclude with one comment. So I was thinking of leading a class action against the WSIB on the basis that they make medical determinations without one single medical report supporting their determination. In other words, they play the role of doctor. So I had one case that was clearly that way. We wrote to 90 injured worker reps saying, "Do you have a case like this?" We got replies from about three of them. Uh, Two out of the three didn't really meet the criteria. And what I'm hoping is starting in January, I'll start to actually call all 90 and see if I can persuade them to do a search of their cases for an example. But what was interesting is this morning I'm going through a case with my associate lawyer, Josh Kirschenblatt, where a psychiatrist has written three reports up to 2023 saying this person cannot work at all. And there are no reports from any psychologist or psychiatrist saying he can work. And the ARO ruled that given he hasn't been in treatment for the past 2 years, there's no reason to pay any attention to the psychiatric report. So essentially, they've made a decision saying he can work. There's no psychiatric restrictions on him working without a single medical report indicating same. So when I'm dealing with my associate lawyer, I said, well, we should get an update from the psychiatrist because now we're going to the tribunal. And if the worker thinks maybe he could work a couple days a week, doing modified work, maybe he should be looking, and then we get a vocational report. And all of these things cost thousands of dollars. Meanwhile, my point of the class action, I completely forgot about it. That, in fact, it was a violation of a justice, which is if you're going to rule against the person, either you better have some very incriminating evidence or you better have a report from another doctor. So I just sent an email
Well,
as we were talking, and it hit me to Pam to put him on our list of cases. But I think what it goes to show is I've become sort of inured to the board, the way the board treats people. The fact that they won't send us an electronic file is a real disservice because then someone has to sit there and photocopy the whole thing to turn it electronically. But I just conclude by saying I've been doing WSIB for around 50 years, and it's been a very difficult topic right the way through. So thank you all for attending, and see everyone again on our podcast soon.
thanks, everyone.
Thank you, everyone.